So you want to have your DUI reduced to a reckless. You've read about it. You've seen commercials. You've read blogs online. And you want to know why. Why can it happen in your case? Well, let's talk about it. Let's talk about DUIs and how they get reduced down to reckless driving charges. Well, if you're in Dade County, Florida, or if you're in Palm Beach County, they have a diversion program. Part of that diversion program is that you plead guilty and you do a set of probation and you get a reckless driving, a withhold of adjudication, so you're not convicted. What happens if you're in another county? So let's talk about Broward County. Let's say you get a DUI in Broward County and you want a reckless driving charge as opposed to the DUI, because a DUI is going to raise your insurance, right? It's going to give you all kinds of things like ignition interlock device, 10-day immobilization, 50 hours of community service, probation from 6 months to 12, driver's license suspension from 6 to 12 as well. Day after day, I get calls. And I do a lot of cases in Broward County. Why can't my case? So here's what we did today. We had a case. Gentleman is alleged to have committed a DUI. His car was allegedly parked in a bus zone. Now, not a school bus zone, but a public bus zone. So where you kind of scoot over, where the bus picks you up. Apparently, the police allege that he was parked there. Now, he's parked there, or allegedly parked there, and fire rescue's called out, the police are called out, and the officer makes a small mistake in his probable cause affidavit. He says that when he arrived, that the EMS had taken the defendant out of the vehicle. Well, one of the elements of a DUI is what the police have to prove, right? What the state attorney has to prove is number one, actual physical control. Was the person driving? So most cases, that's pretty easy. Hi, I'm Officer Smith, and I saw Mr. Jones driving, right? That's element one. Element two is that I believed, based on my training and experience as a police officer, that the individual's normal faculties were impaired. What are normal faculties? The ability to walk, talk, see, hear, and act in emergencies. Or that his blood alcohol level was over a 0.08. So he blew into the breath machine and it was over a 0.08. Or there was a blood test and it came back that was over 0.08. So this client pulled over at a bus stop allegedly. Is the police are called, fire rescue's called, he's taken out of the vehicle. Police officer writes when he arrives that the individual had been removed. Big mistake. Additionally, when we take the depots of the fire department, they have no clue. They don't remember. They're the honest guys. They're the guys that go, you know what? I don't know. That was 6 months ago. I have no clue. Officer goes, I will remember it like it was yesterday. 3,000 arrests later, but he remembers every detail about my client. That's usually the way it goes. So what happens? Well, during the course of this case, as I'm prepping the case for trial, the officer has an internal affairs investigation for perjury. Because he always tells the truth, but he's being investigated by his own department for perjury, right? So, all right. So what happens? Now, that's a logical reason, right, to ask for a reckless driving. When people ask me for reckless driving, you have to have something, right? I have to go to the prosecutor and say, look, I have something that weakens your case substantially, and therefore it would make sense for you to reduce the charge to reckless driving. So I go to the prosecutor, and of course they offer me a reckless driving. They do give me the withhold, so not a conviction, because they usually offer the adjudication. And 12 months of driver's license suspension, 12 months of probation, 50 community service hours, interlock device, 10-day immobilization. So basically everything that's the same. So of course my client's going, what am I paying you for? I could have got that by myself, right? So, that's what happens. I love my clients, but sometimes they they have a friend or a family member, a loved one who Googles it on the internet, and what happens? They go, well, of course you should get a reckless, honey. I mean, why are we paying this guy, Roger P. Foley, to all this money if you can't get me at least a reckless? I mean, simple items. So, on this case, oh, did I mention? The client allegedly blew a 214 or 0.214, which is almost 3 times the legal limit. So we go back and forth and we haggle with the prosecutor. Ultimately, the end result was a withhold of adjudication, 6 months of probation, administrative probation, meaning he just files in with probation one time. As long as he doesn't get in trouble in that 6-month period, then that's it. The case is closed, and he just has a reckless driving. He can then go and seal his record, and then later on in life expunge his record. Well, here's the dilemma. When do I know, as a criminal defense attorney, when it's a good deal, right? I know, based on these alleged facts, that if they put the police officer on the stand and he's been charged or they're doing an investigation regarding perjury, right, then I want to get to talk about it. Now, there's going to be some motions that are going to be filed with the judge, and we're going to talk about some of those issues, but the reality is I'm going to be able to talk about something in regards to perjury, right? So, the first thing that I would talk about is the fact that the police officer did it right, that he saw the individual in the vehicle, that he said that when he arrived, that the fire department had removed the individual from the thing. Removed, past tense, meaning not current tense, right? So this is where all English 101 in college, or if you're a very good student in high school, where when they talked about prepositions and verb tense agreements and all that, guess what? It comes back, because this officer wrote that when he arrived, that the fire department had taken my client out of the vehicle. Not that he had seen that happening, not that it was occurring at the moment, but past tense, that they had taken, right, my client out of the vehicle. So I get to talk about that. Then you mix that in with a perjury. Now you mix in the fact that the state attorney really want to put on a police officer with what's going on in our society. I'm not answering because I'm doing my blog for you guys. And I'm not editing. This is live, folks. Live. All right. So does the state attorney want to put a police officer who has an allegation outstanding of perjury in these times in 2015, when there's all kinds of things in the news about police officers, that police brutality and falsifying documents, beating folks? They probably don't want to do that. Could they do it? So I have to balance. Where's my little Lady Justice? I don't know where she is, but you get the point. Little Lady Justice holding. I have to make a decision and recommend to my client the best course of action. So knowing that they probably won't call the officer, but they may. Knowing that he said something in his police report that referred to past tense, well, he can go, well, that's what I meant. I meant that I saw it, and he can turn it around, right? Or do I recommend to my client that he takes the deal, the lower charge? In most of my cases, I don't make a recommendation either way, folks. What I do is I get the case as low as I can. The charge is reduced. On this case, no community service hours, no interlock, no 10-day immobilization. Get everything is reduced as much as you can with a conversation, and then bring it to your client. Then your client goes, okay, this is the up part of trial. This is the bad part of trial, right? You got to be able to explain to your clients. I think that's why I have a good rapport with my clients, is because I take the time to explain it. Just know, when you want a reckless driving, you want your DUI case to turn into a reckless driving because you've read about it on the internet and you've seen it on the news and some celebrity got it, your attorney must give a reason to the state attorney for them to go, you know what, let me pause for a second. Does that attorney, does he have a point? Reality, folks. is most state attorneys don't care because they're not graded on whether or not they win or lose. So it's trial experience for them. If their supervisor says, go forward, well, they're going forward on a trial, even if their facts aren't good. So that means you, as a defendant sitting at that table, right, sitting at the table, are going to start to sweat. You're going to hope that your lawyer does everything he's supposed to do. You're going to pray. You're the whole time, please let these people understand. But guess what? What if the jury doesn't like this jacket or this tie or this mug, right? Or doesn't like your mug or your frown, and they come back with a guilty? Well, guess what? Now you're convicted of a DUI, and you may do a little jail time, but you're definitely going to do probation, and it's going to stay on your record for life. So you have to make that decision. It's not as simple as, oh, well, I have a DUI, and I hired a good attorney, so they're going to just give me a rec list. The state attorney doesn't care. In my negotiations with the state attorney's office, I have to go through things. I have to walk them through some of the case and what I believe it will work out to be. Now, if I had said, I just want a simple traffic infraction, you don't have enough to prove it. Well, more than likely, knowing supervisors that I know, I'm not saying they're bad people, they're very nice people, but knowing how Broward generally works, that supervisor is going to go ahead and take it to trial. Spend all day, spend 2 days, whatever it takes. Go ahead. Maybe you get a guilty, maybe you don't. Who cares? Well, I care. I'm paid to do the very best job I can for you. So we got to balance that out, and you got to know the positives and the negatives. So if I would have said, you know what, you don't have anything, give me a parking ticket. You know what they probably would have said? See a trial. Now, they may not have, but more than likely you're gonna get that. You know what? I'm just gonna go forward. Now I've done that and I've gotten the traffic ticket, but I've also asked for it and they go, you know what? Like I'm just gonna go forward. I'm gonna revoke the offer that I've already given you. Let's just go to trial. So I gotta tread very lightly, like please, like I want to work with you, Mr. Prosecutor. I gotta pucker up even when I got a great case. Why? I am kissing ass for you so I can get you that reckless. So when you call an attorney, whether it be me or any attorney in South Florida, no, it's not just the books, right? It's not just the DUI handbook. It's not just the evidence book. It's personality. It's persistence, it's knowing the rules, it's knowing your judge, it's knowing your prosecutors, and it's knowing how that jurisdiction works. So you may walk into Dade County and get a rec list like that. Guess why? Anyone can get a rec list because they have a diversion program. But you try to do that in Broward, it's not the same place. So do you want a reckless driving? Yes. You have to, your attorney must find something that would give the state attorney cause to just pause and something is better than nothing. But again, they have nothing to lose. So you want that reckless driving? Don't drink alcohol and drive the vehicle. Yes, it's legal, I know. Be careful. They got Uber, they got all kinds of things. Use them. Use a taxi. Gets expensive when you need me. I'm here for you. But I hope you don't have to go through it because it is a difficult time. It is very exhausting. It's very emotional. You're sitting at the table, right? The table, and you're, please, because you know that if you go to trial on a DUI and you lose, there is a possibility, however slight, that the judge could incarcerate you for some time. Broward, it could be 5 days, 10 days, 30 days, 60 days. The law says that they can give you 6 months to a year. Well, if it's enhanced, they give you 9 months, sorry. Think about what you're asking for. Think about the consequences and talk to your lawyer about it. I'm Roger P. Foley talking about DUIs being reduced to reckless driving.